Labor and the Liberals are going to team up and pass some of the most draconian anti-worker laws this country has seen. And whatever you think of the CFMEU, this should worry you, because Labor has set a precedent where Parliament can seize control of a civil society group that the government doesn't like and suspend their basic rights. As the member for Melbourne said, the New South Wales Council for Civil Liberties has summed it up perfectly. And it's worth quoting here because I don't think every member of this place is taking their responsibility as lawmakers nearly seriously enough, given the enormous overriding of natural justice and the basic separation of powers that this country is meant to run on. Almost flagrantly disregarding our responsibility to uphold the rule of law and natural justice. And if those two principles are to be worth anything, then they should be applied universally. And obviously we have seen some serious allegations made in the media, and those allegations should be tested in a court and under the usual processes. Indeed, precisely because of the seriousness of those allegations, we should go through the court and legal system that this parliament should trust to get to the truth. But instead, as the New South Wales Council for Civil Liberties has said, while any allegation of criminality is serious and must be addressed, the powers set out in this bill are far-reaching and establish a dangerous precedent for the trade union movement, membership-based organisations and the rights of individuals to natural justice and procedural fairness. The rushed nature of this legislation, which is designed to override a process begun by the Fair Work Commission and Federal Court, threatens the principles of natural justice and procedural fairness. We note that the proposed legislation would set a precedent where membership-based organisations can have democratic control externally removed on the basis of untested allegations. This is of concern to all unions, registered clubs and Australian membership-based organisation. The bill violates Australia's obligations under the International Labour Organisation, namely Articles 3 and 4 of the Freedom of Association and Protection of the Right to Organise Convention 1948. The New South Wales CCSL has long held that everyone has the right to natural justice and procedural fairness, regardless of the allegations they face. If this legislation is passed next week, it threatens this fundamental right, the right to freedom of association, and the nature of membership-based organisations across Australia must be protected. And as the member for Melbourne said, they are entirely correct. But the problem is that none of this has been tested or aired in Parliament or inquiries. There's been no coming to terms with the fact that this is an historically unprecedented piece of legislation that sets an extraordinary precedent. And is the government suggesting that they no longer trust the courts or the Fair Work Commission or the Federal Court to get to the bottom of this? Is that the suggestion here? Because that would necessitate surely a full-scale review of our legal system, not overriding basic natural justice and the rule of law. And let's step out some of the things that this legislation allows the government to do. Entirely seize control of the CFMEU through an administrator for a minimum of 3 years, permanently ban officials/workers from ever working for a union again without any proof of wrongdoing, fire any elected officials or staff they wish to without any proof of wrongdoing, and effectively deny those staff or officials natural justice or even standard employer rights. Take control of all union assets, decide when and if elections are called, and completely override the union's own constitution. Now, again, even if you do not like the CFMEU, and clearly neither Labor or the Liberals or anyone in this, a lot of the people in this place seem to just want to crush this union without any recourse to natural justice or procedural fairness, remove the CFMEU, for instance, and insert another membership-based organisation. Imagine if the government was doing that to them, because that is the precedent that this sets. And the precedent it sets is a future government where they decide that they do not like a membership-based organisation or civil society group that happens to offend the government in some way. Well, the government then, rather than take that organisation through the courts for any legitimate allegations of wrongdoing, can pass a piece of legislation based on this precedent that effectively annihilates that organisation. And there's a reason that we have a separation of powers and the reason that we are meant to respect natural justice in this country and the rule of law. Corruption, sexism, intimidation, they should be strongly opposed. And precisely because they are serious and should be opposed, they should be prosecuted through the courts, a system that we have established to determine the truth of allegations and test them properly. Effectively, what Parliament has done is override that separation of powers and declare that they are going to pass judgment on those allegations without any formal legal process. No wonder that there's no members from the government who are willing to speak on this bill, apart from the minister. And at the end of the day, I think a lot of organisations and civil society groups will be wondering, well, what happens when we offend a future government? What happens when a future government decides that they want to crush a membership-based organisation? What happens when that organisation in some way falls foul of the government or the media? Well, now we've seen what the government can do. Why is it? Why is it? We have seen serious allegations made against all sorts of institutions in this country. We saw the devastating impact of the Banking Royal Commission, the impact that the banks had on people's lives. We've seen serious allegations made against previous institutions around systematic sexual abuse. We have seen serious allegations made time and again against institutions in this country, and never have we seen a piece of legislation like this. Why is it that this reaches the threshold to override natural justice and the rule of law, but all of those previous ones didn't? We've never seen a government come and propose to place a bank into administration, but all of a sudden, when it comes to a trade union, Labor and the Liberals are happy to team up and completely override all the basic principles that are meant to define how this country is run.
Authorised by J. McCall, Australian Greens, Canberra.